following program on Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the contempt of court in Sri Lanka. What has the introduction of new legislature contributed to ensuring the primacy bestowed on judicial proceedings? And is there room for more change in the future? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Tonight's topic is a topic I'm sure that a lot of us have already heard about in our social circles as well, and that's on the contempt of court. Now, many would like to argue, is it contempt of court, or is it a suppression of our freedom of expression, or is it simply just the primacy of the judiciary being upheld? Well, to discuss this very complicated topic and to set things straight for us, we have an individual that I believe can do it best, and that is Attorney at Law Nishan Premathiratne. Thank you very much, sir, for taking the time to come to the studio and to explain to our audience exactly what contempt of court is and how it functions in Sri Lanka. Thank you
very much, Anuradha, and thank TV Derana also. Thank you very much.
And just a bit of a small introduction on Attorney at Law Nishan Premathiratne. He has actually functioned as a sector specialist for commercial law reforms appointed by the Ministry of Justice, and presently he is the convener for the Bar Association's Commercial Law Committee and the 50-year Commemorative Committee as well. Safe to say we're in good hands when it comes to this topic, specifically because of his legal expertise. But before we go into the discussion, here's a bit of a breakdown on how exactly we're going to be approaching this topic. First, we'll be talking about the fundamentals of contempt of court. What exactly is contempt of court and how is it defined in the legislature? Next, we'll be going into the current context, the Act, and how penalties are doled out, what regulations actually exist, and if it's genuinely an infringement on our expression. And finally, we'll be talking about international standards when it comes to contempt of court and the future of contempt of court in Sri Lanka.
Hello, my name is Oshadina Nakara and I'm an IT student. My question is on the fundamental of contempt of court. What is contempt of court and what is significance?
Alright, well, without any further ado, let's get right into the discussion. So thanks once again. This is quite a packed discussion, so I'd like to jump right into the questions. I'm sure a lot of us, while we've heard about it in a general sense, we don't exactly know what it is. What is contempt of court, sir? Could you please explain to us?
Yes, Anuradha, so contempt of court is, I believe, the most important aspect of maintaining rule of law. Because if judicial orders are not upheld, and there is no fear instilled in members of the public that if they violate an order of court, that there would be some form of punishment or repercussion, court orders will just be pieces of paper. And in addition, in terms of our constitution, the judicial power of the people is exercised by the judiciary. So people have to believe that the judicial framework is doing what it ought to do. So there is a certain decorum which needs to be maintained. So in order to maintain the efficiency of functioning of the legal system, you need this concept of contempt of court. Because if people start criticizing the functioning ability of the judicial system, that would create uncertainty and raise question marks in respect of trusting the legal system, which is something which is attempted to be prevented through contempt of court. So contempt of court can be broadly separated into ex facie curiae and in facie curiae. So ex facie curiae is something which does not happen in the presence of the court. In facie curiae is something which happens in the presence of the court. So, for example, if somebody is in a courthouse and somebody is disrespectful to a judge, says something or tries to throw something to the in the courthouse, or the phone rings in the courthouse. So those sort of acts or incidents can be construed to be contemptuous. In facie curiae, in a nutshell, is that ex facie curiae is something which happens outside the courthouse. So if somebody, say hypothetically, I come here and I am disrespectful to the legal system, or I say something which is unsubstantiated in respect of a judge, that can be considered to be contempt, and it can be an ex facie curiae matter. But whether it's ex facie curiae or in facie curiae is not settled in written law, but it has been discussed in certain judicial authorities. So in a nutshell, contempt of court is important because it, as I said earlier, it upholds the rule of law. Without contempt, or without a mechanism of ensuring the decorum of the legal system being properly respected, the entirety of the functioning of a judicial mechanism fails.
Right, of course, considering how important it is that the primacy of our judicial system is actually enshrined and actually upheld, we need some sort of checks and balances in order to prevent any sort of going out of hand when it comes to decorum as well. So that actually leads me to my next question, which is on the historical context. How exactly did we come to this point of time where we see such legislature being brought out for contempt of court specifically? How has it evolved over the years?
Well, we had a courts ordinance, we had our Administration of Justice Act, then we have our Constitution, then we have our Judicature Act. Now, in terms of the Judicature Act is the act which gives the power to courts. In addition to the Constitution, the Judicature Act empowers certain courts to do certain things. Now, in terms of Section 18 and Section 53 of the Judicature Act, the power of contempt of court have been given to certain courts. Now, the district court, for example, is the court of first instance, which is set out or situated throughout the entirety of the country, which is adjudicating in respect of all majority of civil disputes. So it makes civil orders. But in the instance of a violation of a civil order, the power to take cognizance of the violation was initially given through the Judicature Act, that is through Section 53. Likewise, the High Court of the Republic. Section 18 of the Judicature Act has empowered the High Court to take cognizance and punish for any act of disrespect of its authority. So Section 18 has empowered the High Court of the Republic. Now, in 1987, we had the 13th Amendment. Pursuant to the 13th Amendment, we had a High Court established in the provinces, that is the Article 154P High Court. So from time to time, this Article 154P High Court was given separate powers. It was given the initially the original appellate, also the appellate criminal jurisdiction, thereafter the civil jurisdiction, original civil jurisdiction, thereafter civil appellate jurisdiction. So that High Court also has been empowered with contempt power through this Judicature Act. Now, all of that was very clear through the Judicature Act, but thereafter on the 1st of February, we saw a new piece of legislature. Now, it is my view that this new piece of legislature did not give a new power of contempt to the courts. It was an act, as the act in its preamble has very clearly set out, it's an act to uniform all forms of contempt of court laws, so that there is clarity, there are proper defenses, there are proper instances which are construed to be contemptuous. So that has been set out. So Section 3 of the Act, the new Act, has set out very broadly what tantamount to being contempt. And then thereafter the Act goes further by setting out specific instances. Now, for example, if I'm in a courthouse and I want to record the proceedings, I might be a lawyer. I might want to be able to not wait till the written proceedings are available. So I might want to switch my phone on and record the proceedings for my own convenience, but seemingly that is contemptuous if I do not get the permission of the respective judge. So I need to do that, otherwise that can be contemptuous. So this new act seemingly has streamlined all forms of laws of contempt. Now, for instance, you can give an undertaking to court. Sometimes in legal proceedings, the opposition lawyer might come to court and say, we will abide, we will not do this act. So that's called an undertaking in law. So previously, whether an undertaking given to court and whether that is violated, tantamount to being contempt, was through judicial precedents, through decisions of court. But now that has been very clearly set out in the Act itself, in the new 2024 Act, which is a good thing. It clears out these objections which can be taken by, in certain instances, by us lawyers. We come and take up certain objections in order to say that there is no jurisdiction to punish for contempt, or we might say that an undertaking does not, a violation of an undertaking does not tantamount to being contempt. So all of that has now been streamlined in this simple but quite well drafted piece of legislature.
Right. So that means while it hasn't introduced new forms of upholding and regulation, it has streamlined everything that was existing. Does that by any chance take away from any sort of flexibility that legal officers would have had when it comes to presenting in court? Is there any sort of negative aspect to the introduction of this new act?
No. Personally, I believe the new act is a timely addition to our written law, because it has now, without any iota of doubt, clearly set out most instances which should be construed to be contempt. Now, whether there is a violation of a order made by a certain court, for example, a tribunal, like a labor tribunal, whether that is contemptuous or not. Now, here in this new act, it is also empowering tribunals. Orders made by tribunals also could be construed to be, if violated, it could tantamount to being contempt. So that is very clearly set out. And also, in addition, defences have been set out. Now, if you, for example, if you, in terms of this act, if you want to criticize a decision, fair comment has been recognized. If you have a valid reasoning to criticize a certain decision, you can. And that is permitted. It is clearly set out. Not blanketly saying the entire system is corrupt, not in that way, but very clearly, if you have a certain reason, you have a valid explanation, you can criticize judgments. And in court anyway, as us lawyers, when we appeal a decision, it is in fact impeaching the lower court's decision. So we will in effect find flaws of that decision when we make submissions to the higher court. But that is not in any way contemptuous. But here, if you go out to the public and you want to talk about a certain judgment, you are seemingly permitted to do so because it is clearly set out. You were permitted to do so even previously. You were given that right of fair comment. Right. That was there, but here it's clearly set out in terms of the new act.
Right, so it's just made vaguenesses completely disappear, and there are very specific areas under which we are protected as well. It's not just that the new act has actually caused some sort of muffling of voices or any sort of shutting out of one side of the ordeal. It's that there are now specific means and streamlined ways to reach whatever goals intended, especially when considering the appeals that will be made eventually. As you mentioned, it is eventually an impeachment on a lower court. But that actually leads me to the next question, sir. Now, in your opinion, what is the most salient feature of the act that has been introduced?
Certainty. It brings certainty to all members of the public. Now, we have had instances where certain politicians have come out and criticized the legal system, have criticized the functioning, members of the judiciary have criticized lawyers. Now, those sort of things, whether that is contemptuous, what sort of punishment should be given, there were defences of that nature taken in contempt of court proceedings which were instituted in the Supreme Court. A famous politician who was found guilty, firstly, and imprisoned for contempt of court, was in that contempt inquiry, took up certain positions saying that, this is uncertain, what is the procedure, what procedure should the Supreme Court follow, whether it is the procedure in the Civil Procedure Code. Now, all of that is very clear. In the new Act, Section 9, 10, 11 has set out the procedure. What is the procedure which should be followed in the Supreme Court? What is the procedure which should be followed in the Court of Appeal? What is the procedure which should be followed in a court of first instance? Everything is very clear, very clear. So, I believe it has brought certainty to everybody. You can't just ridicule the legal system. You should not do that also. You should be very cautious, because ultimately rule of law is not merely things not to be done. When things not to be done are done, the implication has to come through judicial orders. So public trust and confidence is very important in the legal system.
So in a way, this is a way of completely solidifying that the
yes,
trust.
That is my personal opinion. That is my view.
Right. Of course, we have quite a bit more to discuss when it comes to specifics of the Act as well and how it applies in current situations and what we can expect when it comes to repercussions and punishments as well. Before we get into any of that, let's go in for a very short commercial break. You're watching Law, Land and Liberty. Stay with us.
Hello, my name is Silni Bimansa and I am a business student. My correction is on the new Contempt of Court Act. Does the new Act sufficiently address lapses in exciting legislature?
Welcome back to Law, Land and Liberty. We're in discussion with Attorney at Law Nishan Premathiratne. Sir, we just left off on a very momentous segment when it comes to discussing contempt of court and the new Act that has been brought about and how actually considering how streamlined the entire process is now, it's actually much easier for individuals to point out where the contempt might lie and what to do and what not to do. And it's not just blanket statements anymore. I think since we were talking about the Act before we went into a break, it's important for us to continue building on that, specifically when it comes to actually what counts as contempt in the current context, because now we've seen very specific areas being addressed by the Act, which is much appreciated, especially considering how certain things may not even have an intent to be contempt at all. So could you please explain to us what actually falls under the categories of contempt of court right now?
Yes, Anurag. So that's a good, Section 3 of the Act is very clear on that. So if you look at Section 3, Section 3 has set out, so this Act is Act number 8 of 2024. So Section 3 has very broadly said any act done to bring the authority of the court, tribunal or institution and administration of justice into disrespect or disregard. So it's very wide, it's broad. Or interfere with or cause grave prejudice to the judicial process in relation to any ongoing litigation. So anything in respect of an ongoing case, you try to say something about that and you try to scuttle the legal proceedings, outside or inside. I feel even you say something wrong to court, to scuttle a legal proceeding can be contemptuous. So a very broad initial definition of contempt has been given. Then through subsection 2, specific acts have been also stipulated. So willful disobedience to any judgment, decree, direction, even a direction, order or other process of court, tribunal or institution. So anything which the court says, if the court directs you to do something or not to do something, it might not be even termed as an order. So it's very wide. It's very wide. So anything which the court says, you might have to comply. And the cardinal rule is comply and complain. That's what this famous case we lawyers cite in courts prior to this act, and even now I think it has a lot of importance, is the case of Cyril Gardiner. Right? In that, the fundamental principle which was laid down is even if the order is wrong, it might be misconceived, it might be untenable in law, still you have to comply. So willful breach of an undertaking given to court, as I mentioned earlier, that is contemptuous. Expressing, pronouncing or publishing any matter that is false, which or doing any other act which scandalizes or lowers the court, gravely prejudices or unlawfully interferes with the due course of any judicial proceeding, interferes or obstructs the administration of justice. So it's very broad. And then it comes to these specific situations where you're recording court proceedings. That is in 3.2d, Roman 1, Roman 2, Roman 3 and Roman 4. So you're not supposed to keep recording things in a court proceeding without the consent of the sitting judge. So that if you do that without the consent, that can tantamount to being contempt. So scandalizing a court, tribunal or institution or a judge or judicial officer with intent to interfere with the due administration of justice. Excite dissatisfaction in the minds of the public in regard to a court, tribunal or an institution. If you say that, there is something fishy in this court, if you say that without any basis, and even with a basis, you are not supposed to say that. You have to have, that is the defenses come in section 4. Now in defense in section 4, any publication or expression of accurate facts made in good faith of a judge or a judicial officer or a proceeding, judgment or order of a court, tribunal or institution as the case may be on a matter of public interest shall not be deemed to be contempt of that court. So that is specifically provided. It's seemingly capturing the defense of a fair comment, but you have to have a basis. You can't just say things without a basis. It has to be accurate. So if you are trying to discredit a decision, even that has to be accurate. You can't say misleading things. Any publication or expression of accurate facts of any case or proceeding before a court or tribunal or institution made without malice or intention to impair the administration of justice or fair comments on the merits of any judgment or order or an action or application which has been heard and decided shall not be contempt. So it is, I believe this is a very good thing. It clarifies, it irons out, it brings in certainty. Then you have in section 6, which has very clearly given this power which I mentioned earlier of this ex facie curiae power. The Supreme Court and the Court of Appeal, as I mentioned earlier, is the guardian of all courts. In terms of our constitution also, which prior to this act, Article 1053 has very clearly said that the Court of Appeal and the Supreme Court can take cognizance and punish in respect of any contempt done within the presence of a court or outside that court. That is this thing which I mentioned about in facie and ex facie curiae. So about contempt, this act has very clearly broadly defined contempt. The spirit and objective of this has been to ensure due administration of justice, to maintain the decorum of the legal system, to preclude unfair, disrespectful, baseless allegations cast upon the judiciary has been taken away, or was anyway there. This has streamlined it. You cannot say you were unaware, because there is a written certain piece of legislature now before all of us.
So there is quite a few specifics laid out, but that really begs the question now, in a situation where such a breach has happened as mentioned in the Act, where exactly do we find the punishments, and are the punishments that have been the penalties that have been listed out in the new Act, is it, do you believe it's sufficient and to the advantage of the courts, or do you believe there's room for changes and room for more strictness when it comes to that aspect?
So the new Act, unlike the old procedure, envisages the invocation of a contempt proceeding even merely by a motion. So you don't need to file a petition. You can file a motion, and even any person. Now section 9, 10 and 11 has permitted or empowered any person to alert court. The court in its own motion can take cognizance of contempt, or the Attorney General can, together with any document or thing in support of the motion, can alert the court of any contemptuous act, or motion filed by any other person. So it can be even you. You are not party in these proceedings. You have seen something which has happened disrespectful to the court. You can alert the guardian court, that is either the Court of Appeal or the Supreme Court. So it has made it seemingly the legal paperwork required has been made very minimalistic. You have to have an affidavit, obviously. You need to have evidence before the court, any other supporting documents, and merely by way of a motion, you can initiate contempt proceedings. Once contempt proceedings, now this will depend on whether it is in respect of a violation of an order made by a court of first instance. In a situation where hypothetically, Anuradhi, you go to court, get an enjoining order or an injunction preventing a party from using a trademark, and that party is now, after the court order was made, continuing to use the trademark. Now in a situation like that, you have the ability to go to that original court, the court which made that order. So you go to that court and you tell you file this proceeding in terms of this new law now, and you alert the court that the court's own order is now violated. Now it is settled law that in a contempt proceeding, the accuser is not you, it is the court, because it is the court's order which has been violated. It is not my order. I get an order by placing facts before court. Then the plaintiff has an order in his favor. But when somebody decides to violate it, it is disrespecting not the plaintiff, but in fact the court. So that is the whole rationale of contempt in respect of violating an order of a court or a tribunal or any other court of any other institute which is empowered to make orders. So in a situation you can go to that original court where your trademark is now still being used, or you can come before the Court of Appeal as per this new act, or it was anyway, in any event, previously there where the Court of Appeal was empowered to hear matters of violations in respect of orders made by any lower courts of first instance. In addition, if there is a blanket disrespectful act done by, say, hypothetically a politician, he says that the legal system cannot be trusted. So in a situation like that, that is termed to be an ex facie curia situation. The Court of Appeal can, by way of a motion filed by any person or by the Honorable Attorney General, take cognisance and issue, the process in terms of this new law starts by issuing of a rule. A rule is issued, and then the rule is communicated through the registrar of the Court of Appeal on that person. It has to be in person also. Mind you, contempt is a quasi-criminal or seemingly a criminal proceeding. So that is why even in a civil proceeding, once there is an allegation of a contemptuous act, that proceeding becomes criminal in nature. So the criminal procedure then starts applying. So you become accused. You are not defendants. In a civil action, it is plaintiffs and defendants. But when it's where a violation has happened of an order, then that same defendant becomes the defendant accused. So the court goes into a criminal standard. And rather you are aware, now you have the civil standard is on a balance of probability. To win a civil case, it's on a balance of probability. The scale needs to only tilt a little. But in a criminal standard, it's beyond reasonable doubt. So the standard to find a man guilty of contempt of court is on that criminal standard. So the accused needs to come to court in person. In civil proceedings, you file a proxy. Here the accused has to come. If the accused doesn't come, the court is empowered to issue a warrant. So the commercial high court of this country, for example, when there is a contempt of court proceeding which has commenced, can issue a warrant if the accused doesn't come on this contempt summons. So the contempt summons is different to a normal summons in a civil action. That's a summons in the Civil Procedure Code under Form 132. It's a different form of summons, compelling the accused to come to court in person. So now here in terms of this new procedure, the rule is issued, the rule is communicated, and the AG has a very more important role which has been very clearly set out. So the Attorney General has to assist in respect of framing of the charge. Now the charge is the allegation. You have committed the offence of contempt of court by saying this willfully. That is the charge on such and such a date. So that will be assisted in terms of this by the Honorable Attorney General has to assist. So he has a more active role in terms of in facie or ex facie curia as per this act. So I believe the new act has streamlined, as I mentioned earlier, but in addition has seemingly taken away frivolous technical objections lawyers can take.
Right.
Because you have to come. It's seemingly you can't file anything else, a motion or something else on behalf of the accused. The law envisages the accused to come. Earlier also it was there, but here it seemingly places a further burden. You have to come, and the only way you can meet the charge is by the accused filing an affidavit. So he has to say whether he's done this or not. So I believe this makes the contempt procedure more potent, more meaningful.
Right.
It was always intended to be so, but this law has put it in black and white.
Right, and it completely confirms the fact that contempt of court is not something that must be taken lightly, where, as you mentioned, it's not just proxies. There is a standard that must be upheld specifically when it comes to considering the integrity of our judiciary as well.
Yes.
So before we go in for a break, I'd like to ask you a little bit of a question of curiosity. Now, you mentioned earlier on that the process in filing motions and the process that it takes to actually inform the courts of any sort of contempt that has occurred from a third party that might not be related to the case at all has been streamlined. Do you believe that by any chance there is some sort of floodgate scenario that could happen despite all the actions that have been taken in order to streamline and to really give gravity to contempt of court cases? Do you think there's a floodgate scenario?
No, Anurag, it's a good question. I believe Your question has meaning, but I don't believe, because you have to, with the motion, the person who is alleging a contemptuous act to have transpired has to also give an affidavit. So affidavit, if you lie on an affidavit, that on its own is contempt. You see, under the Civil Procedure Code it's contempt, under the Penal Code it's contempt. Right? So you can't give a false affidavit. So if you say something, if you are going to alert a court of a contemptuous act, you have to be mindful. You can't say untruthful things. You can be charged for contempt in doing that.
Right,
so I don't think there is. I think this the fear of the legal system will be instilled more with this new act.
Right. Well, we definitely do have to get a little bit more into the international context as well. Unfortunately, we've come to time in this segment. We do have a bit more to touch on. Before we get into any of the specifics on the international standards and whatnot, let's go in for a very short commercial break. You're watching Lawland and Liberty. Stay tuned.
Hello, my name is Nitmi Vihanga. I'm an IT student. My question is on international standards. Will the new act allow Sri Lanka to stand equal to the levels set by other democratic nations?
Welcome back to Lawland and Liberty. We are in our final segment in discussion with attorney at law Nishan Premathiratne. We were just talking about contempt of court and the new 2024 Act and the significance of this act when it comes to streamlining the entire process of contempt of court and really bringing weight to this concept overall. Now, so we just left off on discussing the very key areas, the salient features, and also the punishments aspect and the procedure related to the contempt of court that's labeled out and listed out in the Act. I think it's an important point for us to understand all of these actions that are being taken in order to bring someone accountable for contempt of court has to be done for the relief of certain individuals. So if by any chance, despite contempt of court being upheld and the judgments being passed, if there is no such relief that has been given to relevant parties, then how exactly are we to believe that contempt of court is a practice that is really upheld in Sri Lanka in the first place?
So I can vouch here that contempt of court is actually happening. We lawyers, we rush to court to get remedies for certain parties, and courts, having been satisfied on the prima facie material placed before the court, sometimes makes ex parte orders. Ex parte orders are orders in the absence of the other party. Sometimes, having noticed the other party, an inter parte makes the orders. So once an order is made preventing a certain act or to maintain the status quo or any other form of order, if that order is violated, the first thing the client or the litigant wants is enforcement. So enforcement of the order is this contempt of court proceeding. So if there is no proper contempt of court proceedings transpiring, as I mentioned earlier, the effect of court orders becomes nugatory. So, but I say contempt of court is taken seriously. You can, if we have several contempt of court proceedings filed in courts in respect of violations of orders. Sometimes it is in the Court of Appeal. It has been, the status of the individual alleged to have committed contempt has been immaterial. Courts do not consider that. Courts will not consider that. So if a person may be from the highest ranking law enforcement officer, there have been examples and situations like that who have committed or violated a court order, and courts have been courts being satisfied has issued the summons of contempt requiring the person to come and answer the charge. So contempt of court is actually happening. And in terms of our law, in terms of Cyril Gardiner, the famous celebrated case, it is also held, it has been held that when there is an allegation of a violation of a court order in an original court, all other proceedings has to be kept aside and the contempt inquiry has to be gone into. So no person who has been affected by the court order can seek to get the court order annulled until and otherwise he answers the charge of contempt. So that is the importance the law has given in respect to contempt, not today, but many years earlier. So yes, contempt of court is active, it's real, it happens, and it enforces court orders, and that is, as I mentioned earlier, the most important way to uphold rule of law. And also now in this new act, Anuradhi, these were always there, but here now in terms of section 6, seemingly it is a very potent provision where immediately the Supreme Court or the Court of Appeal has the power, has always had the power. It could have happened if somebody disrespects a sitting bench in open court, immediately the person can be detained, can be imprisoned. All of that is there, all of that was there, but here it has been put into a written certain piece of legislature. So answering your question, orders are upheld, and upheld through enforcement proceedings, and the public should, I say, have utmost belief that getting a court order means that can be enforced.
Right, especially for the viewers that are watching, it's very important to understand, because after all there has to be some sort of impact and output to the judicial decisions that have been made. Definitely. And for it to be upheld in order for the public to believe in the rule of law that's being carried out in Sri Lanka. So specifically on this point as well, before we go into international standards in the future, when it comes to key authoritative entities and organizations, when it comes to undermining the value of the judiciary and undermining precedents that have been set out by the judiciary, or being called out in public, specifically in for individuals in positions of power and in the legislative body, presumably, how exactly is that going to be handled by this act? Is it being addressed in a specific manner, or do we see any sort of harsher crackdowns on such allegations that have been going around?
So Anuradhi, the judicial power of the people is exercised through Parliament by the judiciary. That is what Article 4 says. So it is actually Parliament who is the utmost judiciary. Now the judicial power is with Parliament. Parliament has devolved that power to the judiciary. So that is why we have seen instances, or the power is always vested with the Parliament to impeach a judge by way of a parliamentary pursuant to an inquiry. Judges have been impeached. We have seen that. So Parliament is superior. Judiciary is seemingly under the Parliament as per the Constitution. So parliamentarians, I believe, have to be cautious, because parliamentary privilege is with them. Inside Parliament, they have the power to, under parliamentary privileges, to criticize, to go beyond the scope of what has been said here. I don't believe parliamentary privilege has been curtailed by this act. So parliamentarians are empowered to say anything in Parliament, within the four corners of Parliament, and I do not believe our law or the judiciary can question those statements. So parliamentary privilege is there, but obviously they have to be cautious, because this is their own limb. The judiciary is their way of exercising the judicial power of the people. So if they start criticizing the judiciary under the realm or the blanket of parliamentary privilege, that will obviously create a serious turmoil, which should not happen. And I believe His Excellency the President also, in a recent situation in Parliament, spoke in this line, and obviously wanted everybody to be mindful of the importance of raising and casting aspersions on the judiciary, and to be cautious.
Right, so there is added caution when it comes to it, but it's not that there is any possibility for it to be completely curtailed, of course. That leads me to a very important point now, sir. We've seen the discussion on freedom of expression being curtailed apparently by contempt of court and other bills that have been brought about recently. Do you believe there's any truth to the entire extinguishing of expression through this act?
No, not through this act. I do not believe. I believe this act is good, it's important. It has streamlined, as the preamble of the act, Anuradhi, has said, and I believe that was the legislative intention also, because I in a recently heavily contested matter in the Supreme Court in respect of a jurisdiction of a certain court on contempt, I had to go into the history of this act, so I perused the Hansard. So even at the Hansard, certain parliamentarian had reinforced that all contempt powers were vested with the courts, and this is an act to merely streamline it. So this has not brought anything new. This is something which was there, which was with the courts, maybe not written, but it was always there. And this has just made it black and white, and this helps.
It's entrenched now.
Yes, and it helps people when they make fair comments, or whether their comment is to be fair or not is something which is now here. They cannot, if you are a non-lawyer, you cannot say that I didn't know that this was contempt. Okay, now there is a written piece of legislature. So I believe this is timely, it's important, and it brings more faith, or it should. I believe that it should, the objective of this is to ensure upholding the dignity and authority of the legal system.
Right, and unfortunately, sir, we've come to time, but before we leave off, I believe it's important for us to touch a little bit on this aspect as well. Before we end this segment, when it comes to international standards, do you believe that while this act has not introduced any new legislation, any new restrictions or penalties, do you believe that this introduction of this act has actually put us on par with certain international standards that already exist for contempt of court procedures and in turn for the upholding of a judiciary of a nation?
So I believe the criticism at a given time was that for certain offences there is no punishment stipulated. Now if you make a remark which is derogatory of the legal system, then what is the maximum punishment the court can give? Now on my perusal, this act has also not set out the punishment which can be given in respect of that. But irrespective, the Judicature Act has set out certain punishments which can be the sentencing periods in respect of violations or disrespect of authorities of the High Court and the District Court. So that is always there. So international community might say you have not addressed this might have been not addressed, can be put in issue. But still, personally, I feel courts are obviously reasonable. Courts have accepted people pardoning pursuant to the same politician who was imprisoned. He pardoned, he apologized to court, and the court accepted the apology and suspended, I believe, his second sentence. So courts are always very reasonable. So this extensive, unreasonable sentencing, I believe, is would not happen and does not happen.
Right. That is actually the perfect note for us to unfortunately end this discussion off on. Thank you very much, sir, for taking the time. I believe our viewers would have much clearer understanding on how exactly contempt of court works, and that this act is not a foe but a friend when it comes to upholding the integrity of our judicial system, and in turn the power that society holds in the judiciary and also in upholding the rule of law. Thank you very much, sir, for taking the time.
Thank you, Anuradha, and I'm grateful to Derana for giving me the opportunity to speak on this. Thank you very much.
Thank you, sir. All right, well, the contempt of court in Sri Lanka is not just a term that is coined to prevent self-expression. It's also a reminder that as a society, we must uphold the significance that the judicial institutions must have in continuing democracy and justice here in Sri Lanka. We leave you tonight with the words of Indian lawyer Prashant Bhushan. Independence of judiciary means independence from executive and legislature, but not independence from accountability. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherthanenglish. Thank you for watching. Have a great night.